Today we're looking at exculpatory evidence. We're asking the question, what is exculpatory evidence? So let's take a look at this very, very closely. So evidence come in different forms, right? So it can come in the form of information. It can come in the form of a document or testimony. But essentially, it's evidence that is favorable, underline this, that is favorable to a defendant in a criminal case. Now, this is very important, students. In the criminal case, not in a civil case, but in a criminal case where there's a substantial risk of jail term. So here we are saying evidence, right? Exculpatory evidence. And we're going to look at the origin of this term. It's not a normal term. It's not a term you use every day. It's not a term you hear every day. So we're going to understand the origin of this term. Exculpatory evidence is information, is document, is testimony, is circumstances that are clear, that are favorable to a defendant in a criminal case. Please take note of this, students. In a criminal case, not in a civil case, that clears or tends to clear them of guilt. Now, it says clear. This is definitive, is it not? When we say clear, that's definitive, or tends to clear. Now, tends is not as definitive as clear, right? But it doesn't have to be clear 100%. All it has to do is to sow doubt that this person is responsible for the crime. Make the jury or the judge doubt the evidence before them that this person is guilty of the crime. So it clears or tends to clear them of guilt. It is evidence that demonstrates innocence. Innocence justifies action or reduces the likelihood of culpability, right? Culpability being guilt. And this is very important. Let's take a look at this again, right? Beginning from here. It is evidence that demonstrates innocence, justifies action. What does that mean? Justifies action. So, for example, if you want to defend yourself, if somebody comes at you and you're defending yourself, and what they see is the outcome, right? You defend yourself. Let's say you strike somebody and the person falls to the ground, and that action wasn't really seen by people, and then they come and arrest you and say you have assaulted somebody. And you say, no, I did not assault him. He was defending myself. He came at me with a knife and I struck him in the head and he fell to the floor. Now, you saw the outcome, but you did not see what I was reacting to, right? So it justifies the action of self-defense or reduces the likelihood of culpability. And here he says, prosecutors must disclose this evidence to the defense. It didn't say prosecutors may or should. Prosecutors, at their discretion, right, will disclose this evidence to the defense. No, it says must. Please take note of this, highlight this. It says must disclose. What does that mean in this context? No choice, right? The prosecutors have no choice but to disclose this to the defendant team. And that is very, very critical because it's evidence that could free somebody of guilt or that could prove somebody's innocence. Let's rephrase that. That could prove somebody's innocence. You cannot, as a prosecutor, hide that evidence. That is against the law. That is unethical. Okay, so what are the key aspects of exculpatory evidence? Let's take a look at the definition. Derived from Latin, it means freed from blame. Freed from blame. Please take note of this. Exculpatory means freed from blame. And what frees somebody from blame in this case? Information, documents, testimony, or any other evidence that could say this person is not responsible for the crime. Now, again, it doesn't have to clear the person 100%. Definition is from Latin. It means freed from blame. It is the opposite of inculpatory evidence. Please take note of this as well. Inculpatory evidence. We're going to talk about this later as a continuation of our discussion of terms. Inculpatory evidence is evidence that suggests guilt, right? The IN is important. Inculpatory, bringing in. Exculpatory, taken out, right? So very, very important. Freed from blame is exculpatory. Inculpatory is suggesting guilt. All right, so the purpose of exculpatory is it is crucial for upholding due process. Exculpatory upholds due process, ensuring a fair trial and preventing wrongful convictions. Now, we all know the legal system in the United States, in Canada, in most Western countries is not the fairest, right? There are injustices, especially to those who are from equity-deserving groups, but are not really getting the equity in terms of the dispensation of law, right? And this is very important for us to understand this. Exculpatory evidence establishes innocence, right? Frees somebody from blame and makes it clear that this person is not responsible for the crime for which they are being charged. All right, so it is crucial for upholding due process, ensuring a fair trial, and preventing wrongful conviction. There is a precedence for this because this is the case law that has established exculpatory evidence as a must disclose for prosecutors, for the prosecution, to the defense. If they have such evidence, they must disclose. The Brady Rule, take note of this, students. The Brady Rule, what is it? So, Brady Rule, established by Brady versus Maryland in 1963. In 1963, the U.S. Supreme Court ruled that prosecutors must, here we come again, we see the term must, not maybe, not shall, not will, not at their discretion, not if they like. It says must, right? Must disclose. This is must. Excuse me. Must disclose any evidence that could be considered material. What does that mean? Material means important, means relevant. Material to guilt or punishment, even if not explicitly requested. Even if the defense is not aware of it, the prosecutors must approach the defense and say, by the way, we have a video that will free your client from blame. We have a testimony. We've seen documents that will free your client from guilt. Evidence that could be considered material to the case, germane to the case, relevant to the case, to guilt, material to guilt or punishment, even if not explicitly requested. Let's take a look at some examples. For example, alibi, cell phones, records, or CCTV footage showing the defendant elsewhere. The crime was committed at 9:30, right, p.m., for example, on, say, February 15th, and the defendant was seen elsewhere at the same time, not at the scene of the crime. He was seen 6 kilometers away from the scene of the crime elsewhere. He was caught on street camera. So that would be exculpatory evidence, right? Because that camera has placed the defendant elsewhere, not at the scene of the crime. This is the scene of the crime. The defendant was here when the crime was committed. Therefore, defendant could not be here, right? Defendant could not be in two places at the same time, could not be here at 9:30. Now, the defendant can be here at 9:45 because of the distance, but the crime was not committed at 9:45. It was committed at 9:30, and at 9:30, the defendant was here, not here. Exculpatory evidence. Witness testimony, statements contradicting the prosecution's witness or identifying someone else as the guilty party, right? Credible statements, right? And it has to be credible. Whoever is giving the statement has to be credible, has to have credibility. That way, the statement and the testimony are believed. So witness testimony can establish exculpatory evidence. Alibi can establish exculpatory evidence. Forensic evidence can also establish. DNA results from a crime scene do not match the defendant's. Not a match whatsoever, right? You are accusing the defendant of rape, and DNA was left at the scene by the rapist, and that DNA does not match that of the defendant. What can you say to that? It's very, very difficult to convict somebody where there is another person's DNA at the scene of the crime. Forensic evidence, the Brady violation, if prosecutors withhold, suppress, or fail to disclose such evidence, it constitutes a Brady violation which can lead to a conviction being overturned, and the prosecutors might get in trouble as well. This is very important. Please take note. Let's take a look at this again. Brady violation, what is it? If somebody says, oh, that's a Brady violation, if prosecutors withhold, suppress, or fail to disclose such evidence, it constitutes a Brady violation, which can lead to a conviction being overturned, which can also lead to the prosecutors getting into legal trouble. And finally, let's take a look at the impact, students. The impact is what? The impact of exculpatory evidence is what? The evidence must be strong enough to potentially change the outcome. This is so key, to potentially change the outcome of the trial or create reasonable doubt. That's all it has to do. To create reasonable doubt that you cannot pinpoint this person with any level of certainty that this person was responsible for the crime. You cannot do that because you don't have conclusive evidence, right? You do not have conclusive evidence to place this defendant at the scene of the crime because defendant has an alibi that put him somewhere else at the time of the crime. A witness testimony states this person was not the one that committed the crime from a credible source, of course. Forensic evidence, DNA evidence, fingerprints, somebody else's, not the person that committed the crime. You cannot convict this person except you have evidence that is strong enough to place this person at the scene of the crime and to suggest that this person is the one that committed the crime or was an accessory to the crime. Now, you don't have to be at the scene of the crime to be guilty of a crime. You can be accessory to a crime. So, Brady violation, once again, if prosecutors withhold, suppress, or fail to disclose such evidence, it constitutes a Brady violation and it can lead to a conviction being overturned. It can also lead to a case being tossed out. And the impact is the evidence must be very strong, must be strong enough to potentially change the outcome of the trial or create reasonable doubt. This is exculpatory evidence. Exculpatory evidence is very, very critical, and it is predicated on a 1963 case where the Supreme Court established that prosecutors must disclose any evidence that could be considered material. Material is germane, material is relevant, material is very important to the guilt and punishment, even if not explicitly requested, even if the defense is not aware of it. The prosecutors are under legal obligation to disclose.